In state judiciary, top position occupies the High Court, and below the High Court, there are hierarchy of subordinate court. The institution of High Court was set up in 1862 when three High Courts were set up, and these three High Courts were at Calcutta, Bombay, and Madras. And these three High Courts are set up under the Indian High Courts Act, under the Indian High Courts Act 1861. The Constitution of India provides for a High Court in every state. However, 7th Constitutional Amendment Act of 1956, 7th Constitutional Amendment Act of 1956 authorizes the Parliament to set up a common High Court for two or more states. Presently, there are 25 High Courts. Among the 8 union territories, Delhi is the only UT which has a separate High Court. Delhi is the only union territory has a separate High Court. Union territories of Jammu and Kashmir and Ladakh have a common High Court. Constitutional provision. Article 214 to 231 in Part 6 of the Indian Constitution deal with the organization, independence, jurisdiction, powers, procedure, and so on of the High Court. Now let's see composition of High Court. Every High Court, whether exclusive or common High Court, consists of Chief Justice and such other judges as the President determined. As the Constitution does not specify the strength of the High Court. Now let's say appointment of judges. Same as Supreme Court. But there is only one change in the consultation process. In case of appointment of a judge of a High Court, Chief Justice, Chief Justice of India should consult two of his senior-most judge. And in case of Supreme Court, it is four of his senior-most judge. बाकी सब सेम है. Now, qualification to be a judge of High Court. First one is should be a citizen of India. Second, should have held a judicial office in the territory of India for 10 years. Should have been an advocate of a High Court or High Court in succession for 10 years. There is no provision for a distinguished jurist. In case of it is thus clear that Constitution has not prescribed minimum age as qualification. Next topic is oath or affirmation. Takes oath before the governor or some person appointed by him, appointed by governor. Next is salaries. Salaries and allowances are determined by Parliament from time to time. but it cannot be varied cannot be varied to their disadvantage after their appointment, except during financial emergency. The retired Chief Justice and judges are entitled to 50% of their last drawn salaries as pension. As pension. Next one is tenure. First one is hold office until he attain the age of 62 years, and any question regarding this age is to be decided by the President after consultation with the Chief Justice of India, and the decision of the President is final and binding. Second is can resign his office by addressing the resignation letter to the President. Third one is can be removed from his office on the recommendations of the Parliament. Lastly, he vacates his seat when he is appointed as a judge of the Supreme Court or when he is transferred to another High Court. Next is removal. Same process as Supreme Court. Next is transfer of judges. Article is 222. President can transfer a judge of a High Court to another High Court after consulting with the Chief Justice of India. In 1977, Supreme Court ruled that transfer could be made only in exceptional cases and not exceptional cases and only in public interest and not by way of punishment. In the third judge's case, Supreme Court ruled that in case of transfer of a judge of a high court to another high court, CJI should consult CJI should consult in addition CGI should consult in addition with the fourth senior most judge, two Chief Justice of High Court, one from which the judge is being transferred and another is receiving him. बाकी सब सेम ही है. And last topic is jurisdiction and powers of High Court. First is original jurisdiction. Original means power of a High Court to hear dispute in the first instances and not by way of appeal. Let's see original jurisdiction of the High Court. First one is disputes relating to the election of members of parliament and the state legislature. Second one is regarding revenue matter or an act done in revenue collection. Next one is enforcement of of fundamental rights. Next one is cases transferred from subordinate court. Involving the interpretation of the Constitution. Lastly, the four high courts, these are Calcutta, Madras, Bombay, and Delhi. Have original civil jurisdiction. Before 1997, 1973, these four high courts also have original criminal jurisdiction. But this was abolished this was abolished by the Criminal Procedure Code of 1973. Next one is writ jurisdiction. High Court can issue writs not only for the enforcement of fundamental rights but also for other purposes. Writ jurisdiction of the High Court is wider. That is why the writ jurisdiction of High Court is, is wider than the writ jurisdiction of the Supreme Court. High Court can issue writs to any person, authority, and government not only within its territorial jurisdiction but also outside its territorial jurisdiction. In Chandra Kumar's case, 1997, Supreme Court ruled that both writ jurisdiction of Both the High Court and Supreme Court constitute a part of the basic structure. Hence, Parliament cannot amend it. Appellate jurisdiction. Two type of appellate jurisdiction: civil matters and criminal matters. In case of civil matters, first appeals against the order and judgment of a district court, additional district court, and other subordinate court lies directly to the High Court on both question of law and fact. If the amount exceeds the stipulated time. Second one is second appeals from the judgment and order of district courts and other subordinate courts lie to the High Court on question of law only. Some High Court have provisions for intra-court appeal. What is intra-court appeal? When a single judge of a High Court decided a case and appeal lie to the division bench of the same High Court. Fourth one is appeals from the administrative and other tribunal lies to the High Court. Now see, in case of criminal matters, Appeals from the judgment of session court and additional session court lie to the High Court. If the sentence is one of life imprisonment for 10 years, sorry, not 10 years, life imprisonment for more than 7 years. Death sentences awarded by session court must be confirmed by a High Court before it can be executed, whether there is appeal or not. Superintendents of High Court is very broad because it extends to all courts and tribunals covers not only administrative jurisdiction but also judicial superintendents. It is a revisional jurisdiction. Can be a suo motu and not necessarily on the application of a party. This is all about High Court. दिस इज ऑल अबाउट हाई कोर्ट. बाकी सब सेम ही है. जो सुप्रीम कोर्ट में है वही हाई कोर्ट में है. सो देयर इज नो रिक्वायरमेंट फॉर डिस्कशन. दैट्स इट.